You can put property that you own in a different state into a trust that you set up in the state that you live in and maybe own your primary home in. This is estate planning lawyer Michael Pevney, and I set up estate plans for California families. I have a fair amount of clients that own their primary residence in California, and they might own a rental property. That rental property might be in California, might be in another state, and maybe they're setting up that rental property to be owned long term, or maybe they plan on moving there one day, or maybe it's a vacation home that they own. Fair amount of people in California own properties in places like Arizona, Texas, Florida, Tennessee, Idaho, Washington, Michigan, New York, all sorts of places. And when we set up an estate plan, I usually, as the centerpiece of that plan, set up a trust, a revocable living trust. One of the main reasons that we want to set up a trust is to avoid probate. And so by putting property inside of that trust, it will avoid probate. Probate is the court-supervised asset distribution program. The courts run it. In California, it's very expensive. It takes a long time. The average homeowner in California that I serve is avoiding $50,000 to $70,000 in probate costs by putting their primary residence into a trust. But what happens when somebody owns property in another state? So a lot of people don't necessarily like to invest in rental properties in California because property values are very high, and you can get more for your money based on what the rental amount is versus the purchase price, have a higher rate of return by investing in out-of-state rental properties. So a fair amount of my clients do that. Sometimes it's in an LLC, sometimes it's not. Most important thing always for this is having good insurance, good homeowners insurance. Make sure that there's good accounting on all of this, and we're not fudging any of our taxes, that we are trying to avoid taxes, but not do any sort of tax fraud, anything like this. All right, so I digress. So we can put an out-of-state rental property into a California trust, and it's relatively simple. So let's say somebody owns a home in Texas, and what we do is we write up a deed and we file it in the county where the property is. So if I owned a property in Denton County in Texas, all right, that's outside of Dallas, and I rent that property out and I'm setting up my trust and I put my own personal residence in it, what we do for the primary residence in California is we write up a deed. We say, I, Michael Pevney, as an individual, am deeding this property to Michael Pevney as the trustee of the Michael Pevney Living Trust. And we basically do the same thing in whatever county in Texas that this property is owned. So Denton County outside of Dallas, we say, I, Michael Pevney, am deeding this property to Michael Pevney as the trustee of the Michael Pevney Living Trust. So what that is going to do is consolidate the ownership of all of this property into one single entity, into that one trust. And that also means that in Texas, that property will not have to go through probate in Texas. Now, specifically, Texas probate is not necessarily as long or as expensive as it is in California. However, if property is owned by an individual in another state and it's not subject to a trust, meaning there's no estate plan going on at all, it would actually have to go through probate in that other state. So when I have clients that have properties in multiple states, if they passed away without an estate plan or without the home being added to that trust, they would have to go through multiple probates in multiple states, which often means hiring lawyers in those other states, each of those states, in order to get those homes distributed in the way that they wanted to. So by adding out-of-state properties to a trust, we avoid probate in multiple states, not just California, but whatever state those properties are in. Now, when we get into international properties and even territories like Puerto Rico or Guam or somewhere like that, oftentimes they don't necessarily follow the same estate planning rules that the US does. In foreign countries, it's almost a universal no. If somebody owns a property in Mexico or somewhere in Europe, it's very difficult and typically impossible to put those properties inside of a United States-based trust because they have their own estate planning rules, their own probate codes, and their own ways that things have to be distributed. So that usually means going into an international lawyer. But you can put an out-of-state property into a trust that you set up and create in the state that you live in. If you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for a free estate planning strategy session. If you're interested in more estate planning information, please like this video and subscribe to this channel for more estate planning information. Thanks for your time and thanks for your attention.